Same-sex marriage and divorce. Same-sex marriage is now legal in all parts of the United Kingdom following Northern Ireland's decision to legally recognize same-sex marriage last year. What is same-sex marriage? Same-sex marriage is the marriage of two people who have the same gender. It can be entered into both a religious ceremony and a civil ceremony. The Same-Sex Marriage Law in England and Wales. The Marriage, Same-Sex Couples Bill received Royal Assent under the Conservative and Liberal Democrat coalition government in July 2013. The Act enabled same-sex couples to marry in civil ceremonies as well as religious ceremonies, where the religious organization has opted in to conduct the ceremonies. It also meant that those who had entered into a civil partnership were able to convert their civil partnership into a marriage should they wish to do so. As well as allowing same-sex marriage, the Act also enabled those who wished to change their legal gender to do so without having to end their marriage. When same-sex marriage was legalized. Same-sex marriage has been recognized and performed in England and Wales since March 2014. The first same-sex weddings took place on the 29th of March 2014. Where is same-sex marriage legal? Same-sex marriage is legally recognized and performed in a number of different countries throughout the world, including the UK, France, Germany, Ireland, and Spain. Same-sex marriage and divorce. Until no-fault divorce becomes a reality in England and Wales, it is necessary to prove that a marriage has irretrievably broken down and give one or more of 5 reasons or grounds for divorce: unreasonable behavior, adultery, desertion, separation for 2 years or more, consent from the other party is necessary, and separation for 5 years or more, with consent not necessary. Adultery can only be grounds for divorce when sexual intercourse takes place between a man and a woman. Adultery cannot be used as a reason for divorce if the sexual intercourse is between two people of the same sex. However, rather strangely, if one person in a same-sex marriage has sexual intercourse with a member of the opposite sex, then this would be grounds for divorce, as it would fall into the legal definition of adultery. If one party in a same-sex marriage had sexual intercourse with a member of the same sex who was not their spouse, it is likely that the party petitioning the divorce may be able to apply for a divorce, citing unreasonable behavior as grounds for divorce. Many argue that this outdated system does not reflect the way society views marriage and should be changed to keep up with both societal views and same-sex marriage legislation. If the no-fault divorce law is passed, this should hopefully put an end to this rather bizarre rule which affects same-sex marriage divorce in what seems to be an unfair way. Austin Kemp, by your side.